Good afternoon, all you cool cats and kittens. Quick shout out to the Tiger King reference. Do want to appreciate your time for us today. I know there's quite a bit of webinar activity, so I do appreciate your attention during this time and very much value you jumping on here and sorting through these issues. As you know, today's webinar is Navigating Law Firm Financing in Pandemic Times. We have really great panelists that have years and wealth of experience dealing with financing of law firms and just financing in general. So we're going to really cut to the heart of the issues, get to give you information that can help you and your firm navigate through these difficult times. I'll quickly go through all of our different panelists right now, and then as I introduce them, I'll give them the full bio. But coming up first, we have Matt Walsh, who is an SBA financial, is on the FBA Financial Assistance Services team leader at Witham. Second, we have Jeff Grossman, who is the head of client strategy and advisory at City Law Firm Group. Third, we have Paul Cody, who is president and CEO of Counsel Financial. And then we're going to end with Mark Evelyn, who is the CEO of Verus. So I just wanted to thank you all the panelists for making your time today, and do appreciate all the great content we're going to deliver to everyone on the webinar. And for all of our attendees, you know, we're gonna chop some of this out and give this make this video available on our different platforms and social media. So we do appreciate you sharing that upon seeing that in your different feeds. First up, we have Matthew Walsh. Matthew Walsh is, as I mentioned, he's on the Financial Assistance Service team at Witham. He has over 7 combined years of professional public accounting experience involved in auditing, specializing in professional services and manufacturing, distribution, and logistical industry. He manages many consulting and due diligence projects with companies in the professional services and distribution industries, and has a strong experience in auditing of employee benefit plans and compliance with Department of Labor Relations. He's got his Master of Science in Accounting from University of Pittsburgh. He is a licensed certified public accountant in New Jersey and Pennsylvania. And without further ado, I would introduce Matt to the panel and just kind of go over and speak to the content, and anything else you wanted to highlight that I missed in your bio, please feel free.
Nope, I think you got it all, Dan. Thank you. I appreciate the opportunity to be here with everybody, and I hope that everybody is doing well and staying safe, you know, during this difficult time. So, you know, to kick things off here, you know, one of the topics that I'll be touching on is regulatory programs to help with business continuity, you know, during the COVID-19 crisis. And I think when we think of the regulatory programs, we, you know, kind of automatically go to the loan programs that are available, you know, under the Economic Injury Disaster Loan Program and under the Paycheck Protection Program. Those are certainly the sort of headline grabbers and, you know, the most notable areas. And I will speak a little bit to them, but I did want to, you know, kind of kick us off with a couple of areas that are just available out there to companies such as law firms that are going through these difficult times, just like the rest of, you know, of the small businesses out there. You know, the first of which is something that became available through the Phase 2 legislation, which was the Families First Coronavirus Relief Act, known as the FFCRA affectionately. What this did, this provided a tax credit for, you know, for those companies who were footing the bill for sick and family leave employees who were affected by the crisis. And what this, what it allowed companies to take advantage of is 100% refundable payroll tax credit to, you know, reimburse dollar for dollar those expenses that are spent on sick and family leave as a result of the crisis. So that's one thing that is out there. What I will note is that a lot of these provisions have some level of interplay if companies also receive the Paycheck Protection Program loan, whereby if you receive a credit somewhere, they're not going to allow double dipping elsewhere. So, you know, that's something to keep in mind. Another one that I wanted to mention here is the employer retention tax credit. You know, this is a tax credit that's available out there for companies who had a substantial reduction in revenue. I think the actual definition is significant decline in revenue, which you know, they define as a 50% reduction in revenue on a quarterly basis in comparison to the quarter in the year prior. And what this refundable tax credit is good for is up to 50% of the wages of individuals up to $10,000. So it's a potentially $5,000 credit. And this has to be renewed on a quarterly basis and reviewed in comparison to prior year sales. So that's out there as well, as far as you know, as far as some cash flow opportunity for businesses. The final one I'll talk about before we get into the loan programs is the payroll tax credit. So the employers are allowed to defer their portion of employer FICA taxes. And what this allows you to do is avoid paying the 7.45% on the gross wages paid out to employees. Now, early on, there was the thought process that this was not going to be allowed if you obtained the Paycheck Protection Program. However, the IRS, two Saturdays ago, came out with a very favorable ruling that companies who obtained the Paycheck Protection Program or were applying for the Paycheck Protection Program could, in fact, receive this payroll tax credit up until the point at which the loan forgiveness decision was handed down. So for those of you out there who, entertained this and reached out to your payroll companies and they said to you, well, you have to certify that you're not getting the Paycheck Protection Program, or you have to certify that by doing this, you're giving up your opportunity. That is no longer the case. So we do recommend that you are reaching out to your payroll providers again, if you haven't already had the opportunity to, and, asking them if this is available. Certainly not the level of funding that something like the Paycheck Protection Program or the EIDL would provide you, but any level of increased cash flow during this difficult time is important to consider as you are managing your business. With that being said, I'll pass on to the two loan programs that are available. The first of which is the Economic Injury Disaster Loan Program. This is a loan program that has been available for many, many years under the SBA. In the Northeast region, really the last time it was heavily used was during Hurricane Sandy. But the loan program has always existed, and basically for a declared emergency, companies who have an economic injury can apply for this loan program. This program is facilitated through the SBA directly. So to the extent that companies are interested in applying for an economic injury disaster loan, they would go to the SBA directly. They would provide documentation such to prove their economic injury, and the SBA loan officer would work with them to determine their injury and determine a loan. For this, the maximum loan amount is $2 million, 3.75% interest rate, which is fairly reasonable. And the payment plan will be determined by the SBA. Early on, we heard that these loans were pretty limited in nature, but we are starting to hear the system loosening up. There were some more funds agreed upon by Congress and the White House recently to add to the pot for this plan. So, we are expecting that this will, continue to flow, and individuals who applied who maybe haven't heard back yet may start to hear back over the next week or two. I'll add one caveat to the EIDL program, that there is this comes with the EIDL grant, which was a grant of up to $10,000. After the fact, they kind of changed the rules on this one and indicated that they would only be giving $1,000 per employee up to $10,000. This grant would not have to be repaid, provided that you don't also get the Paycheck Protection Program. Again, that's another situation where they're not allowing double dipping. So if you do get that EIDL grant, you would not be able to get that same $10,000 forgiven under the Paycheck Protection Program. And then finally, we have, certainly the Paycheck Protection Program, which is the headline grabber here. There's been a lot of criticism of how this program has played out early on. It was based on a first come, first served basis, and the monies ran out pretty quickly. And Congress has agreed in principle with the White House that another $310 billion will be added into the program. So we are going to look to see that this program starts back up. They've already doled out the original $349 billion that was associated with the program. The most popular provisions here, obviously, are the forgiveness portions, whereby an employer is eligible for forgiveness to the extent that they pay they use the loans for allowable expenses, for forgivable expenses, and follow the spirit of the law such that they use it to maintain payroll and keep their employees gainfully employed over the 8 weeks after they get the loan. So at a high level, that kind of covers from a regulatory perspective, the availability of funds or cash flows to help businesses continue through this difficult time. And with that, I'll kind of pass it back to Dan to talk about some other options as well.
No, absolutely. Thank you so much, Matt, for that. And just to all of our attendees, any questions about what Matt spoke about, and for all the panelists, please submit them through the Q&A portion of the Zoom. So at the very end, we're going to go through and answer every question relative to the panelists. So if you have any questions about what Matt just spoke about, please enter them into the Q&A, and at the conclusion of all the panelists, we'll go through and address all of those individual questions. So thank you so much for that, Matt. I do appreciate it. Before we move to the next panelist, I just wanted to say thank you to all of our first responders, all the doctors, the nurses, and all of the healthcare infrastructure that's helping through this COVID pandemic. Generally we've started out every webinar with that, so we missed that. I just wanted to double back and just say thank you to everyone. And thoughts and prayers with all of the attendees and panelists that have family, friends, or loved ones that are dealing with the COVID-19. So thank you for that. Again, keep the questions coming. We're seeing a lot of activity there. We do appreciate it. And now I'm going to move to our next panelist, Jeffrey Grossman. Jeffrey Grossman is the head of client strategy and advisory at Citi Law Group. He returned to Citi almost 2 years ago. Previously, he was the co-head and co-founder of Wells Fargo Legal Specialty Group for 14 years. And he's worked in the law firm industry for over 20 years, and his banking career spans 35 years in various lending businesses. He knows his stuff. So without further ado, Jeff, if you want to introduce the topic of what you're talking about, and again, any questions surrounding what Jeff is saying, please enter them in and we'll address them at the end.
Thanks so much, Matt, and appreciate to be here with all of you. As Matt said, I've been in the banking business for over 35 years and worked with law firms for 20 years and was the architect and author of the Wells Fargo law firm survey and have been actively involved in Citi's survey as well. So on the advice side, I've been working with firms for many, many years. Most of that advice has been geared toward fee billing firms. However, we do work with many class action contingency-based firms across the country. And the things that I'm about to talk about, none of you unfortunately are immune from too. Although I would say at the end of the storm that we are facing, or this virus that we're facing, both physically, health-wise, and also economically, I do think there's a pot of gold for your sector of the industry, and I want to talk about that. I just thought I would open with two quotes because sometimes I think we all need some inspiration. Then I'll talk about some of the sources of funding and financing that the industry does have, as well as what the outlook is. Number one was from Ernest Hemingway, and that there's courage is grace under pressure. And I think we just all need to remind ourselves that and keep cool heads as we're going through this, because we will get through this. And my view is that we have to survive to thrive, but we will thrive at the end of the day. And then the other one is, as you are making decisions and actions, this was from Will Rogers. Good judgment comes from experience, and a lot of that experience is from bad judgment. In other words, we all make the best choices that we can at the time, but I'm pretty confident that most of those choices will put law firms in a strong position. Our outlook, and this is no different if I were talking to a fee billing firm or firm that's revenues are on a contingency basis, is that the outlook from a revenue or receipts point of view is questionable right now. I actually heard an acronym a bunch of years ago that I've stolen called SWAG, in terms of trying to forecast the outlook of what we think will happen with second or third quarter, or even for the full year collections for this year. And SWAG stands for Serious Wild A Guess. You can guess what the A stands for. It's anybody's best guess. I mean, in your industry, your sector of the industry, I've found during good times, you're actually pretty good at forecasting your revenues, maybe not quite exactly in the timing, but pretty good at forecasting your revenues. But right now with the timing, I don't think anybody, fee billing or not, can really forecast when receipts are going to come in. We're seeing essentially all of corporate America build and preserve cash on their balance sheet, cash conservation. We're seeing every law firm of every type considering or doing the same type of thing. And as a result of that, all type of receivables and collections and payables are slowing down and are expected to slow down. It's a little bit unknown how much that is going to be. But what I would tell you is that we're seeing firms modeling for worst case scenarios of slowdown of their receipts of 50, 60, even 75% for the quarter or two. Whether that is ultimately going to be a case or not, nobody knows. I think it's important to have modeling in place so that you have your playbook. There's no precedent for the playbook that we see today. Even if you go back to the financial crisis, it was impactful to our economy, but it wasn't terribly impactful other than for a few months to the law firm industry, because frankly, there was a lot of litigation associated with it. Right now, we're seeing every industry in the corporate sector being affected, every American in some way being affected, and every part of the law firm industry potentially being affected. And so it's as a result of that I think we're all here to talk about what are the financing and funding sources. Collections and timing, I think, is in question too for your sector of the industry. As we all know, courts have been down dramatically, and timing is just off. There is some work going on from a litigation point of view, from a prep point of view, but new cases are really slow to get started. And I've already talked about the forecast. In protecting your firm, with my expression of it's important to survive to thrive, cash is king, or cash, as I would put it. And there are very sources of cash to help you weather the storm. But I heard one law firm chairman put this really well and said that the cash is the levee that's going to keep the dam from being breached during the storm. And the source of cash that we see from a bank perspective are your bank lines of credit. And I want to talk about that, but I thought I'd also give you just a little bit of context. Credit is tightening in this country from a traditional banking source. Why? Well, just what I described. Most of the corporates in America have drawn down significant amounts under their financing arrangements. The bond markets have largely dried up for them, so they've leaned on their banks in a way they haven't in the past. And we saw each of the top banks see over $100 billion of drawings over a 2-week period of time from their corporate clients. In addition to that, if you look at the rest of the economy and look at middle market America, same thing. Many of them have been drawing down on their lines of credit, and law firms have been doing the same thing. So as a result of that, there's pressure from a return on capital from a bank perspective. What we don't see is right now a liquidity crisis or a funding crisis for the banks to be able to fund, because they're well capitalized, but they are starting to tighten up. So pricing of credit and availability of credit from a bank perspective, traditional lines are becoming less available and are taking certainly a lot more time. I could tell you that at Citi, within a 1-month period of time, we booked more credit than we have booked in the entire past 2 years. And at first, as bankers, we thought it was manna falling from heaven. And over time, we started to take a pause and look at the capital that we were putting into the industry and becoming much more selective. So I would suggest to all of you, to the extent that you have traditional lines of credit, that you'd be looking at the structure of those lines of credit. First of all, are they committed lines of credit, contractual, that the bank must fund? In the past, I've seen many, especially in this sector of the industry, that the lines of credit are what I'd call demand discretionary lines of credit. They're there, you don't pay a fee to keep them in place. We call a commitment or unused fee, and the bank can at any time at their discretion pull it. And that has never really happened in the past, but I do think today it'd be wise to ensure that those lines are committed. Look at the size of the line of credit. What you might have thought was necessary in the past may be different today. We see many firms of all different types looking at the size of their line of credit, and if they had 1 month of operating expenses, or if it was based on a certain level of inventory pipeline that was in place, now actually looking to amp it up 1, 2, 3-fold from where it was before. And as I said, right now that's becoming more and more difficult. Look at the length of time that the line of credit is available. Make sure it's going to be long enough to carry you through the storm so that you're not renegotiating during the storm. And as I've mentioned, very much as a defensive move, many law firms have drawn down on the line of credit and have put the cash in the bank simply because they're being risk averse. They don't have an identified need for the money at this point in time, but they're being risk averse. The second source that I would see in terms of financing options, we talked a bit about the PPP, and the advice I would give you there, rather than talk about what the program is, because we've already covered that, is none of the banks except for the state or community banks were really well equipped to meet the PPP needs in the 9 days from the day that Congress had authorized and the president had signed in the original program to the final date of funding before it had closed, or I think it was a little over 2 weeks when it finally closed. And many found themselves in a position where their applications were in queue in the bank, especially larger banks, but they did not get funded. I would urge all of you, if you haven't been funded, and if you put in an application, to talk to your banks and make sure you understand exactly where it is in the queue. Until you have an E-Trans number that's been transmitted to the SBA, and then you get an SBA loan number, you are not approved and you're not going to be funded. We do think there'll be a 100-yard dash to the finish line again. Hopefully this time it lasts longer, and we're not going to lose the 9 days or so that it took the large banks to put programs in place, which they had not previously been equipped to do. But there are going to be many that are competing for this number. So timing is of the essence, and understand where you are. Other sources of funding or financing for the firms, and I'd actually call this preventing release of cash that you may have on your books. Partners. We're seeing across the industry all type of firms that partners are either getting no payouts or partial payouts, whether that's if there's a draw system, which is less typical in your sector of the industry, or in addition to that, if there are distributions that were to be made, perhaps you had a win that just came in, not distributing that money, keeping it on the balance sheet. As I said, cash is king. To the extent that any of you have payments to retired partners, we're seeing deferrals of many of those payments to retired partners at this point. And then beyond looking at the cash that we can preserve by not paying out to partners, and it's starting there from the point of view of both, it's the largest opportunity to preserve cash. And also, if you're going to make other changes at the law firm, you have to all be in, so to speak. We're seeing, of course, the changes in terms of staff, whether that be furloughing, whether that be layoffs, whether it be reduction to comp. And I think you'll see many more that will reduce comp, less apt to lay off, and especially in your sector of the industry where we do think there'll be a major resurgence in the near future. But we'll see that at staff levels, lawyer levels, and then really targeted performance evaluations of more senior lawyers, whether it be counsel or income partners, to the extent that your firm has the like. Rent is something that we've heard many firms discuss. I would just tell you that right now, landlords are not going to have very much sympathy for you in terms of rent abatements or rent deferrals. They are drinking through a fire hose and using the fire hose to put out the fires with the retail sector. And then putting off any other fixed expenditures, IT, or other type of projects. You know, our outlook as we look forward, as I said, from an economic point of view, we expect the economy to take roughly 9 quarters to get back to where it was pre-COVID. And that's as of today. And as we talk to our economists, that literally is changing every day with a negative bias in terms of the outlook from week to week. But as of right now, we're looking at about 9 quarters before we get back to where we are in the overall US economy. I don't see that for the law firm industry in general, and I particularly don't see that for anybody that's involved in litigation, whether it be on the defense or on the plaintiff side. Right now, we have a lot of pent-up litigation that ultimately will go through the system. And if we start to get back to work in the summer, we may start to see the lights going sooner than that. But if we get back to work in the summer, I believe a lot of that will come online. And I also believe that as a result of COVID and also the financial impact of the financial crisis that we're in again right now, I believe there'll be a major resurgence of litigation. So my advice is, in addition to looking at your financing from a traditional banking point of view, is look very, very hard at any action that you can take that'll preserve cash, because there's only going to be so much availability from traditional banking or other alternative sources in the times that we're in. Is going to be the cash that ultimately protects you. Thanks, Matt. Let me hand it back to you.
All right, thank you so much, Jeff, for that. I do very much appreciate you. Definitely dove in pretty granular on that, so I appreciate that very much. I know a lot of the questions. If anyone has questions, I see a couple in the Q&A. One of Jeff's associates, Bola, will be answering that. I'll go through her bio at the very end. So, Jeff, I know you have a hard stop shortly. I do appreciate your time very much.
Thank you.
And any questions regarding what Jeff said, please enter it in through the Q&A, and we will address that through one of his associates. Thank you so much.
Be safe.
Yeah, be safe, absolutely. again, appreciate everyone's staying on. All the attendees are staying on, so we absolutely love it. Appreciate your time. Without further ado, we're going to turn to Paul Cody. Paul Cody is the president and CEO of Counsel Financial. He is a rock star in the mass tort and litigation space. He is a certified public accountant licensed in New York with over 25 years of experience in the private equity and financial service area. Prior to joining Counsel Financial as president in 2008, Paul was general partner and chief CFO of C Partner Capital, a private equity fund with a focus on early stage investments, and John Ron Management, a closely held private equity fund with investments interests ranging from non-recourse plaintiff funding to commodity-based financial products. Paul's career began at KPMG, one of the world's largest accounting firms. He holds an MBA and Bachelor's of Science from SUNY Buffalo and has certified as an adjunct faculty professor at its School of Management. Ladies and gentlemen, he knows his stuff. So without further ado, Paul, I will let you introduce your topic, and do appreciate your time and love your background up there. So.
Thanks, Dan. And for full disclosure, Dan added some creative color there. I didn't self-proclaim to be an expert in mass torts and class action. I can in the next few minutes. So a little bit about Counsel Financial. For those of you who don't know us, we are a commercial lender. We have been in this space lending exclusively to plaintiff law firms, not corporate firms, defense firms, or for that matter, any other type of asset class for the last 20 years. I think we're the longest that have been in the space. We've lent to literally hundreds of firms around the country and over $1.5 billion over that period of time. So, we've got the benefit over, a pretty extensive period of time of seeing what happens, not just in good times, but in bad times. And I think what I want to talk a little bit about today are some of the options that are out there for financing. Maybe you echo a couple of the comments that were mentioned earlier in terms of how you should be being proactive in handling things within your firm as well. But, we'll share those comments. Hopefully we'll add a little bit of color. One of the things I think is really important to notice or to note here is that clearly we're in a recession. And I think Jeff covered that. And there's been at the early onset of this was a question of what was ultimately going to be happening here. Was this a temporary thing, or was this going to be a longer sustained issue? There's no question that this is a recession. There's no question that this is a significant issue for the economy, and it's going to affect virtually all of us. Unless you run Netflix or some other streaming service, you're going to feel it. Over the last really month, we've seen 22 million people file for unemployment. They're projecting unemployment to be north of 13%, when just less than 2 months ago it was 3.5%, which was almost a historic low. So I think really what the question for the people on this call and what we're trying to evaluate is, how deep is that recession? How long will that recession be? And then most importantly, how does that impact you? I think that there's, a variation of what's happening. Some of the comments I think that Jeff had made certainly would apply to plaintiffs' practices. I think it's an acute impact on the corporate firms. We've seen, almost every Am Law 100 firm has made reductions or, deferred partner comps or done furloughs, things along those lines. Fortunately for us, and we have been in constant contact with our clients, over 100 firms across the country, just to see what kind of impact that they're feeling. And, happy to say that it's better than what we're seeing in the overall industry. And that, doesn't mean that you're not feeling it, doesn't mean that there's not an impact. And certainly the more prolonged this will be, the more of an impact that will ultimately have on everybody. But in the short run, I think a lot of firms have been able to be agile, been able to use technology, depositions via, different platforms like Zoom, like this, as well as others, to be able to kind of keep moving their practice along. And even the liquidity has been okay. One of the biggest things that we saw, and the best correlation that we're trying to grab from, is the Great Recession of 2008. What happened there, and how did firms sustain during that recession? And one of the things that's paramount is, what's the stability of your firm? How do you weather the storm through all of this? And most importantly, how do you weather the storm? And I think one of the things that Jeff had mentioned is forecasting revenues. There is no question, I think, that the impact here is going to be a delay in when you receive cash flow. He also made a comment about liquidity in the market, which was a huge issue back in the 2008 recession. And what happened there is, because there was a lack of liquidity in the market, it was a trickle-down impact to everybody, in particular in this industry, because the insurance carriers were trying to preserve their own capital. So they were paying their claims out more slowly. Self-insured defendants, same thing. To preserve capital, there's plenty of ways to not go to the settlement table, plenty of ways to kind of defer things from in the court system. And of course, you've got the compounding of the court systems being, in disarray right now. Even though some are starting to come back online and they're doing their best, there's no question that there's a significant delay. So how do you match that up, and what do you do in terms of trying to prolong the livelihood for the firm? So Jeff also had mentioned, and what we certainly have seen is you should be looking at all of the different options that you have. Both Matt and Jeff talked about the stimulus, the PPP program in particular. Clearly, we don't have to beat that horse. I think everyone on this call hopefully has applied for the PPP program. Every plaintiff's law firm should be looking at it. Potentially, if you're keeping your employees on, that's free money. It's a grant. But it's a short-term solution, right? Essentially it's 250% of 1 year's or 1 month's worth of your payroll. So maybe that carries you a couple months when you factor in the other overhead and other expenses. So go after that. Get the stimulus package money if you can get that. If you haven't applied, do it right away. It's first come, first serve. I think Matt had mentioned earlier, they allocated another $310 billion. We're expecting that to be approved as early as Thursday. So that pipeline should hopefully open up. Most of you who have applied are probably a little frustrated. A handful maybe have received those funds, but a lot of you are either in the queue or just really, working the phones to see where you sit in the queue. So take advantage of that. The second thing is, if you have a line of credit with the bank, that's terrific, a traditional line of credit with the bank. You've got, you should look at that line that you have and talk to them. The government and the regulators are giving them more flexibility. So if it's, a scenario where you need a little bit of flexibility in terms of timeframes and your cash flow, ask for that flexibility. What we have seen and heard and, even experienced is that most of those traditional sources are going to be available or going to be able to accommodate in some fashion if the need is there. If you don't have a line of credit with a bank, again, as Jeff had mentioned, there's some significant credit tightening and it's happening in the industry. And for anyone who's in the plaintiff practice who has looked for traditional bank financing already, that it's a difficult proposition. It's not easy to go out and get a line of credit as a plaintiff's practice. In short, banks really don't understand your most important asset, which is your cases, your contingent cases, and they have no real means to value those cases, there's no third party like an appraisal that can be done for a piece of real estate or a financial statement. Your financial statements don't show your contingent fees. So what else do you do? The other options are people like us, of course. So, the commercial here for us in terms of Counsel Financial, that's what we do. I mean, we are providing a line of credit, very much like a line that you would receive from a bank. The difference is that we value your biggest asset. We value your contingent cases. So we'll use that as a primary basis as compared to your personal net worth, your personal liquidity. We'll use those cases as a basis to determine how much we can lend. And that typically is as much as 3 to 5 times as much as you can get from a traditional banking source, assuming that you have, a significant stable of cases. So another good news, I guess, is that you have the cases that you have today, despite the economic conditions, is that there's not directly a correlation. Your significant kind of catastrophic injury type of case that you have today should not be worth less in April of 2020 than it was worth in January of 2020. We saw that back in the last recession. In 2008, the value of a significant injury case was not different than it was in 2007 or 2010 or 2012, cost of living aside. So those values should be able to uphold during that time frame. And then another option I'll throw that's out there is there has been, like prior to 2008, and when you have a sustained, prosperous economy that we're in, there's a lot of money that comes into this space. So when I say a lot of money, I'm referring kind of loosely to Wall Street money. So there's a lot of private equity, hedge funds, et cetera, that are trying to deploy as much money as possible with litigation firms. And the reason is what I just mentioned in terms of the asset being kind of quote unquote uncorrelated with economic conditions. Your values don't change, even though the timing may change. So there's money that has been available there. We'll see how available that money is on the other end. In 2008, a lot of those options disappeared, and they were very prevalent leading up to the recession. Not sure what'll happen. Time will tell what'll happen on the other side of this transaction. But if you do look at those options, all I'd tell you is just be cautious, because there are some pretty onerous terms you have to be somewhat aware of. There are terms where, we've had prospective borrowers of ours that we've started to work with, and they've got $3 million sitting in a bank account that they're paying 20% interest on. We're saying, how can you possibly be doing that? It's because the lender wanted to deploy all the money up front. So that money is sitting there. So you can't just pay interest like you do with a traditional line with a bank or a line with counsel, where you pay interest just on what you borrow. They want to deploy the money kind of in chunks. There's also, be careful about really onerous prepayment penalties. So if you get into an agreement, we've seen prepayment penalties north of 15%. So just caution you when you're looking at those options. Be aware of the devil's in the details in terms of what's there. So again, going back on this, I think it's really, how do you sustain yourself through this process? It's really about the law firm stability. What's best for you, obviously, in turn, is best for your clients. And to be able to weather the storm, cash is king. I agree with the comment again from Jeff earlier, is that, you want to make sure that you have the availability yourself. Preserve your existing capital. You don't want to be in a situation where on the other side of this, you are essentially in the same boat in terms of your cases or your potential revenues, but now you're just in more debt. So you really want to manage the best you can during that time period, but explore those options that are out there for you in terms of getting additional capital. So while the banks are tightening, we're not, and a number of other, options may not be as well. Last thing I'll tell you is, be proactive in your practice. Whether or not it might not be as similar for a plaintiff's practice, it's often not than in a corporate firm where they look at their partner draws and they look at, how they're furloughing employees and the correlation in terms of what happens with your revenues. Your revenues were always, volatile in this space, but be careful, make those decisions that you need to make. A lot of firms also don't really differentiate the firm separately from themselves as individuals. So you should do that. Think about from yourself, what can you be doing individually? Your mortgage, you may have an ability to defer mortgage payments. You may have to, whether that's on your corporate, your lease, or for yourself personally. You may have the ability with your landlord. I know Jeff's comments where they're not going to go show you a lot of sympathy, but some will show some flexibility because frankly, that they have no choice. So take a look across the board, how you can be preserving capital. And, and as a final point, what I would say is, if times get stressful and you're sitting there thinking that you have no cash and how do you weather the storm, remember that you do have this asset, which even though it's not liquid in the sense, it's the value of your cases. And those cases can be used for purposes of a line of credit. They can be used with other law firms for co-counseling arrangements, joint ventures, even mergers or acquisitions. I mean, some of that stuff will happen more frequently in a down scenario like this where cash starts to tighten. So you have that as an asset that you can utilize to be able to weather the storm, and you might have to be creative about how to do that. Certainly we're in the business to lend money and we're interested in that, but we also are, consultative with our clients or our prospective clients. We'll tell you if we think that you could, would qualify for a loan with counsel, but if not, we can also kind of bounce ideas. We've put a lot of firms together and have helped a lot of firms look at different options that don't simply revolve around increasing the debt that they currently have. So, it's pretty much, an open book, and we're happy to be consultative the best that we can and don't charge, separately for that. So just some different things to think about, but best of luck to everyone and stay safe. I'll kick it back to you, Dan.
Paul, thank you so much. I do appreciate the creative approaches to weathering the storm that you just mentioned there, and obviously everything. I also do appreciate you allowing me to go a little off the cuff there on the bio piece and talk a little bit. I do appreciate it, but I do think anyone that has any questions, please enter them into the Q&A. Anyone that has any questions for Paul that is on the webinar after, please reach out to me and I will forward your contact information to Paul as well and his team. I know Paul's team has and his entire company has done an amazing job putting out information, content, and really getting in front of all of the clients' needs. So thank you so much for that, Paul. I do appreciate it. Like I said, any questions, please keep them through the Q&A. I think we have a lot kind of flooding through, so I do appreciate that. All the attendees are staying on, so Do appreciate that as well. Without further ado, we're going to move to our fearless leader, Mark Eveland. He's the CEO of Verus, one of the founding partners. Mark began his master's career in 1993 in a large consulting firm. For those of you who don't know his extensive bio, and he's been assisting clients involved in asbestos, breast implant, other large-scale product liability before founding Verus, and obviously his work at Verus speaks for itself. Obviously, I know one of my mentors at the company, Dan Meyer, and Warren Iverson know Mark, and obviously as founding members of Verus, they've worked together for quite some time. But during my tenure, I often struggle back and forth, what's bigger, Mark's brain or his heart, because he really genuinely cares about the underlying claimants and comes at the entire approach of the company in a very strategic fashion. So it is with a great honor that I introduce Mark Eveland to the panel. And any questions surrounding his content, please save for the end. But Mark not only knows his stuff, but he comes at it from not only a strategic and a totality approach, but from the underlying claimants. And we facilitate justice every day is the mantra that Mark has hammered, and all of our employees of our company have bought into this. And I think the overwhelming effect of that has just helped all of our clients and the industry in general. So thank you so much, Mark. And if you can please, wrap up with the general comments surrounding the webinar.
Okay. Well, I'm going to keep my remarks brief because we want to get to Q&A. Thank you for that introduction. You're very generous remarks. I'm glad the wall behind me is red because I'm blushing right now. But I just want to thank everyone for taking the time here, Paul and Jeff and Matt for participating, and Bola, who's going to join us for the Q&A, and all of the attendees taking time out of your busy days. This COVID-19 crisis, I'm sure, has put a lot of things on all of our plates. But we thought this was an important topic for everybody who's in attendance today, because really the goal here is to make sure that the services that your firms and firms like Verus and Counsel Financial and Witham and Citi provide to support your firms, that your firms survive through this crisis, and you're given as many levers you can pull on to make sure that happens, because what you do is very important to your clients, and your clients are among some of the people who are suffering the most from this crisis, and they're going to need you on the backside of this. So we want to make sure that you're fully equipped to get through this, protect and preserve your firm and your team so that you're there for your clients when this is all through. One of my favorite quotes is from a French philosopher from about 400 years ago, Michel de Montaigne. He once wrote that his life had been full of terrible misfortunes, most of which never happened. I think there's a kernel of wisdom in that we all need to right now be planning for the worst and hoping that those things don't pan out. And the more we plan for those worst case scenarios, the more we increase the probabilities that we'll be able to avoid them. So I would hope that you all take what you're hearing today, factor in some of the information that Matt and Paul and Jeff have provided to you into your thinking, and come up with a great plan to make sure that your firm gets through this and survives, to steal a quote from Jeff, survives so you can thrive in the future. I believe that there's going to be an explosion of litigation when this is all through and the dust settles, directly related to COVID-19, and you can already see the early stages of that in some of the class actions that have been filed against retailers, manufacturing facilities that didn't take prudent steps to protect their employees and their customers, cruise lines, a whole host of industries that are going to be subjected to mass tort and class action litigation when this is all through. That's all I wanted to say today, and with no further ado, I'll turn it back to Dan to take questions.
Thank you so much, Mark. I do appreciate that. And just to quickly touch upon something you mentioned, we've had conversations, and we as a company have conversations surrounding the explosion of litigation. Something I just wanted to quickly highlight. I believe, and I know a lot of the attendees and panelists also agree, that mass torts and class action is a team sport, right? So the more we all collaborate and rise together and really meet the needs of the claimants and the injured parties and victims, that the industry as a general will do better. So I know we at Verus here are very excited to rise to that occasion and looking forward to servicing not only the law firms with individual claimants to the best of our capacity. So thanks so much for that, Mark. Do appreciate that. We're going to go through a lot of the questions that are coming through. And I think, Matt, this one might be for you. Payroll credit, is it real credit or a deferral?
Sure. Great question. So the employer tax, the employer portion of the tax is a deferral. Employers are allowed to defer those taxes, and they're repaid at the end of 2021 and 2022. So it's essentially a loan product as opposed to a forgiveness product or a credit.
Excellent, excellent. And this might be for either Paul or Matt. So why did some banks get started much later than most others regarding the PPP loan? So that, Matt, that might be you actually.
That's a great question. You know what? I think a lot of it has to do if you look at the data that's come out from the banks and what we've heard from some of the banking contacts across all levels of banks, whether it be down to the community banks up to the largest of the large banks. The guidance was unclear at best on how ultimately payroll costs were going to be calculated and how the multiplier was going to be affected, and was the 100,000 limitation including all costs, or were they in addition to? What about partnership income? There were so many items that were unclear. I think getting systems up and running with the amount of variables just took a different amount of time at each of the banks. And then on top of that, I think some of the legal departments wanted to make sure that all of the the T's were crossed and the I's were dotted before taking on potential liability. I certainly invite Paul's thoughts on this because I know that I'm sure that he has some based on his experience, but that's kind of what we're hearing.
Yeah, I would agree with everything that Matt just said. Best advice that we have and we've been sharing with our clients, I think I said it briefly in my presentation, is that go to where your relationship is. Even though some of the largest SBA lenders in the country, Wells Fargo, some of the big names, banks, B of A, et cetera, they are so inundated with the amount of applications that they've received. Wells at a point in time had some capital constraints that they had as a result of some issues that Wells had before. It was a regulatory issue that they were dealing with. So they capped how much they were putting on their balance sheet. I think they've loosened that up since. But I remember early on in the first, I think 2 or 3 days, Bank of America had almost 200,000 applications. So what's happening is this queue and this backlog is just insane. And there's 30 million small businesses across the country. I think that there was, in the ballpark, when the money ran out from the first 350 million, there was about 1.2 million applications that were in at the time. So that leaves 29 million or so, additional small businesses. Not that they would all apply, but whatever percentage of that is a huge number, and it's first come, first serve. So even some of the smaller banks that are not necessarily traditionally SBA lenders or have never lent for the SBA before, it's a relationship. If your trust account, where you have a lot of your funds and you regularly work with, that bank is going to be approved. Any federally insured bank is approved to process these applications, and they're going to prioritize. There's some litigation actually that came out around this, but they're going to prioritize who they have the best relationships are. They're going to want to make you happy with your trust accounts more so than they are somebody off the street who's coming in for an application. So I'd say, use those relationships when you have them.
All right, thanks so much, Paul and Matt, for that. I do appreciate that. We have another question that just came in. There are so many companies already in queue, all the delayed in queue at all the delayed banks customers, including Citibank, are being penalized. I don't know if that's so much a question, but just a general statement, but I think that does any of the panelists want to address sort of all the different queues, or was that generally addressed in your comments there, Paul?
Well, what I wasn't clear on, maybe Matt will know better, is when they had fully deployed the cash flow, the first 350 billion, and now, as they said, there's 310 billion that's going to be approved, we think, by Thursday. The Senate approved it. The House and the president have to sign off, but what I had read today was that that should happen Thursday. And that's probably not the end of it. What wasn't clear to me is the queue. Was it completed in full and allocated and those funds haven't been dispersed yet? Or have they actually dispersed all of the funds? I don't know, Matt, if you have any clarity on that, but regardless, the queue itself, in the backlog, just imagine processing these number of claims and the amount of time that they're processing the number of claims. I think I read something that the SBA, the number of transactions in the SBA in a 14-day period exceeded what they had done over the last, I forget what it was, 2 to 3 years. So, just the volume is just overwhelming the system.
Yeah, I agree, Paul. And what we have heard, it's tough to separate sometimes, complete and total facts. But what we have heard anecdotally is that, actually, I shouldn't say anecdotally. Marco Rubio tweeted out, I think it was 2 nights ago, that the SBA has over 800,000 applications in their possession that are not approved yet because they don't have funding. This to me means that they were submitted into the E-Tran system by individual banks already, and they are awaiting loan numbers. So the general process is such that the bank approves the application, approves all the funding, submits it to the SBA. When the SBA to the SBA's E-Tran system, when a number is assigned, that means that funds allocated. Funds are available to be allocated to that. And when you get a loan number, that's when you know that the funds are, essentially assigned to that EIN. What's unclear is whether or not those 800,000 applications were as of when the funds were shut off last Thursday, or if that 800,000 includes everything that has been queuing up since then. It's really unclear. But what I will say is, if you take that 800,000 and apply it against the average loan amount from the first tranche of monies, you're looking at about half of this 310 billion already spoken for, and that's before the process even opens up again. So again, I think before Jeffrey hopped off, he gave the advice that you stay in constant communication with your banks, and we recommend the same thing. Make sure, if someone hasn't reached out to you yet, that you've spoken with somebody to make sure that they are they are getting you in that queue and that you are in line to be submitted to the SBA. And if not, maybe it's best to search an alternative lender who you think would be able to do that.
Thanks so much, Matt and Paul. And we do have another question coming in here, and obviously any of the panelists and Bola, who is a colleague, an associate of Jeffrey, is because he had a hard stop, will be potentially answering some of these questions as well. And I open this up to all the panelists. If businesses have received PPP funds, should they be segregating these in separate bank accounts to track their expenses? What kind of documentation will be necessary to apply for forgiveness? So if everyone wants to just add a little bit, maybe we'll start with Matt, go to Paul, and then end with Bola if they want to just add a little flavor on each of that would be fantastic.
Sure. I'll kind of talk through, for my portion, what's actually in the law on this one, and then, just a little bit of what we've been advising. So there is no provision in the law that says you have to segregate the funds into a separate bank account. From a documentation standpoint, and what you're ultimately going to have to end up proving, it will likely be easier to show the trail of cash and that you used the funds for the proper amounts if you are able to do this. As far as the law goes, again, there's no requirement that you have to do this, but it's probably going to be easier on the back end when you're providing the documentation. As far as what's required, the law, the CARES Act requires that you provide all documentation to prove pretty much every expense, and that includes payroll reports. It includes, proof of full-time equivalents that were employed during both the covered period after you get the loan and the periods in which you need to compare it to, which includes 2019 and part of 2020 or part of 2020. It also includes canceled checks, which is where the idea of having this segregated comes in handy. You can kind of prove the whole trail from start to finish of what you spent. So all that's going to, kind of come into play. So that's kind of where our view of the world currently. And just to, an extra point is that as we've all seen on the news and, on Twitter or whatever social media platform we follow, the tone around the overall forgiveness, calculations and how the forgiveness is going to occur has not certainly gotten any lighter. We're seeing this shift, which is to a more conservative approach, and it's probably going to be expected that the SBA is going to follow suit with a little bit more, harsh regulations around this. So, to the extent that you keep those, those records, clear and concise, it's going to probably behoove you on the back end.
And thank you so much, Matt. In the essence of time, Paul, can you just give a little bit of flavor to that if you have anything to add? Or
well, the two real quick comment on is that the design of the program is to keep people off unemployment and keep people employed by their employers. So the primary use of funds is, I believe, 75%. Specifically in the regs, but the primary use of the funds is for payroll. So if you're using it for payroll, if it's consistent with your historical numbers, just have the records to support that.
And from my own read of the laws and the regulations that have been published so far, it strikes me, and this might be something that Matt can speak to, there are a fair number of ambiguities in the forgiveness regulations that you put out so far. It's going to take careful consideration and some good professional advice to navigate that forgiveness request.
Yeah, it's definitely true. There's pretty much every portion of the forgiveness calculation has at least one ambiguity. A colleague, of mine at Witham, we wrote an article together that pointed out 17 areas that need clarification in order for a true forgiveness calculation to be done. So these are questions that need to be answered, and I think if you do a quick Google search, you'll see that a lot of professionals, attorneys, accountants alike have asked some of these similar questions.
all right, thank you so much, Matt. Bola, are you there? Can you hear us?
Yes, I can. And I totally agree with Matt and Paul on the last comment. Having a separate account is not required. Probably makes sense for tracking. And definitely, I think we're going to see more come out around forgiveness and the requirements. It's probably going to be a bit more stringent as time goes on and all the public opinion out there. So from a bank's point of view, if you go to your regular bank, it shouldn't be that difficult. It would just be another account, based off of your existing profile. So it should be an easy one, but it's not required.
Thank you so much. And Bola, we have one other question here for you. If what information is available on the way the forgiveness calculations are going to work? Do we know everything we need to know? How should business owners be approaching the forgiveness considerations?
So I would say that, I'm not sure everything is out there already. I mean, anyone who listened to the press, the daily announcements would know, just that there was more to follow. I think the SBA is unfolding more information as days go by, so we expect more in that regard. But going to the SBA website is definitely the first place to go to. I would say that we should definitely, the accountant, whoever the firm's accountant is, and the attorney that who serves as the general counsel, they all have opinions there. The other thing I'll say is I don't think that there's a uniform way of reading this yet, because just from talking to our clients, people have shared with us, well, this is what my counsel says, this is what my accountant says. So I think we're still in a holding pattern here, and more to follow. So going to the SBA website, seeking counsel, and waiting for more. We're going to get more clarity. Because I think the first focus of the SBA was to just get the funding out there, and then there'll be more attention around forgiveness as the days go by.
Great, that makes a lot of sense, Bola. Thank you so much. I know we have one last question here. I know in the essence of time, if the attendees want to stick around a little bit longer, we're willing to do that. By all means, I know we're going to flash all of the panelists' contact information. If you're not able to see it and you're just calling in from your phone, or you're walking around getting your quarantine laps around your house or your apartment, please feel free to reach out to me. I will pass along any information regarding all of our esteemed panelists. This last question is for Paul. You had mentioned earlier surrounding your firm being around during the Great Recessions. What specific lessons did you and your clients learn about how to survive, and the current theme, right? Survive and thrive. How to survive and thrive during that period that could be lent forward to this period?
Sure. So it's a kind of a collection of things that I was trying to cover there. Is, I agree. I think it was a common theme: preserve capital internally. Look at how you're spending money. Look at the vendors and lenders that you have currently in place, and see what kind of flexibility you can get there. Explore options to give yourself new capital. Not that you should use it, but get yourself lines of credit availability if you need it, just so you have that to be able to weather the storm. And if you feel like you're really in a bind, just be creative, looking at other options that are out there. Just don't assume that the only path here is that you need to fund it yourself or that you need to borrow. There's other ways to to have benefit out of an asset that you have, even though the asset is not liquidating or may not be liquidating as quickly. I mean, your cases are not coming as quickly to resolution. There's options.
Awesome. Thanks so much, Paul. I know here at Verus, we're coming up with creative ways surrounding our contracts and our clients to be able to work with everyone. So obviously everyone here, and I know that has come directly from top leadership on down, and be able to come up with creative ways to work with each other during this time, I think is very important and pivotal. So any of the attendees that are on the call that have questions surrounding how we work through some of these issues, please feel free to reach out to myself. Again, for those of you who don't know, my name is Dan Caminar. I'm the Director of Business Development. Any of the other panelists, as you can see, here's all of their contact information. Again, if you just have your phone out and you're just walking around, reach out to myself, and I will, myself or Veronica, we will distribute all of their contact information. I thank you, all of our esteemed panelists, for your time. We have one last question, and we covered that, so do apologize for that. I just wanted to thank all of our panelists. Matt, thank you so much. Paul, Mark, Bola, Jeffrey, thank you all so very much. Again, we're going to be distributing some of this, so if you like the content, please share it out. If you have questions, please reach out to us. If you want to critique it, please reach out to us. But again, we are all here. We are all in this together. Us as an industry, together, if we work together, we will rise all ships. So thank you so much for your time. I do very much appreciate it. And thanks so much.